Watch closely. This isn't just another arrest. That man on your screen, he's got 13 felonies. Like, in this time, the judge's patience is gone. What happens inside the courtroom next, you won't believe how fast everything flips.
I've had a chance to review that letter. Mr. Truch, are there any other additions, deletions, or corrections?
No, Your Honor.
Okay. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Judge.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of people for allocation today?
Yes, as people also were just recently shown this morning, a letter from the Lions. As much as we would like to believe that Mr. McKenzie is finally recognizing he has issues and in fact is now wanting to seek some help, the facts are belying that, in that these are his 12th and 13th felonies. His outstanding warrants from Kentucky. It's the situation where under the guidelines, he's 12 to 36, so he's looking at incarceration. And back on November 25th of 2004, he received a 207-day sentence on his 9th felony. As the court's well aware, when persons keep repeating the same behavior over and over again, you get past the point of rehabilitation, and you get to the point where there has to be progressive penalties and sanctions. This is such a time, and again, I think that should be dealing with fleeing or looting and resisting and obstructing charges. And Mr. McKenzie not only places himself, officers, but the public in general in risk because of his actions. He should be held accountable for that. Thank you.
Thank you, Mr. Truch.
Thank you, Your Honor. I have been familiar with Mr. McKenzie basically since I arrived in Otsego County a little more than a decade ago. I've dealt with him and his family a fair amount. When I look at this PSI, I certainly can understand the recommendation that's made here. As we look through the compass narrative, right? What are the areas that are identified as needs for Mr. McKenzie? Leisure and recreation, social isolation, substance abuse, cognitive behavior, family criminality, vocational education, residential instability. All of these are needs that can and are being addressed through the Lion's Den program. I certainly can understand that there's history. The vast majority of Mr. McKenzie's history is nonviolent history. It's property crimes. Frankly, the vast majority of his history, I think, is poverty driven. But that's really neither here nor there. I would suggest to the court, I certainly do think that the guidelines require something to be imposed. I think the question the court's going to have to answer here is, how is society better served? Is society better served if Mr. McKenzie is given a MDOC sanction or, I don't know, midpoint of the guidelines is probably what, about 20 months or so? Is that what best serves society here? Or is he better served by continuing the program that's working well for him? Continuing a program that's going to put him in position to not be continuing to repeat the same patterns over and over. I think that the community is better served with him completing the program. And I think a sentence can be crafted in such a way that if he does not complete their program, he doesn't comply and he doesn't change his behavior, he faces that sanction. The low end of the guidelines here is 12 months. If the court were to impose a 12-month jail sanction, hold it in abeyance pending his completion of the Lion's Den program, I think that strikes the right balance both of punishment and rehabilitation. It punishes the behavior, it takes into account and recognizes that the behavior is inappropriate and dangerous, but it also recognizes that he's in a position to make meaningful changes in his life. He has more support through the Lion's Den than I think he probably has again, in at least the 10 years that I have been familiar with them. So what I would suggest to the court is I think that better serves the interest of the public than imposing an MDOC sanction, which again, likely has him back in the community, probably without the same benefit of the intervention that Lions Den is going to give him. Thank you.
All right, thank you. Mr. McKenzie, anything you'd like to say?
Yes, Your Honor. I've had more change in my life in the 3 months that I've been at the den than I have in the 41 years of my life. Growing up, I've never really had direction and guidance and love, and I have received every bit of that from the den. I am out there helping at food drives, but all over the area, whether it be the Michigan Works, the Roscommon County Sheriff's Department. I'm also the automotive equipment manager at the den. I keep all the mission vehicles running and operating correctly. There's so many positive things that's happened in my life and that I'm able to put out towards the community and also within the house that I've never had the opportunity to have before. If I would have had this years ago, if I even would have known about this, been able to implement this program, I guarantee a lot of the things that I did in my past would have never happened. And I just humbly request that that you please allow me to stay in the den and complete the program, because it is an 8 to 10 month program, but I'm also allowed to stay on the staff and help others that were in my situation, that were doing the same things that I used to do, and help them and prevent them from messing up further. And I understand that there is a reason to put a sanction on me, but I just humbly request that you could hold that in advance and allow me just to complete the program. I've already gotten so much just in the 3 months. I only can imagine what I could gain in the 8 months from that, and then to be able to stay on for staff. So.
Thank you. I did review the report, so I'm familiar with your circumstances, your background, and your history, which is not good, as you well know. Numerous felonies and misdemeanors. I also reviewed the information in the report about the incident that brings you before the court here today. And I read the letter, obviously. Clearly, it sounds like based on from the Lions Den perspective, you've been doing some good work there, and that certainly warrants consideration. And then, of course, what the lawyers had to say and yourself here, taking all of those things into consideration. There's a couple of things that really stick out to me. Number one is your prior history. You got a demonstrated long-term history of engaging in criminal activity, and whether it's assaultive or not, what it's driven by doesn't really matter to the people who have to deal with the crimes that you've committed and are victims of that. The crime in this particular case is concerning to me because it does involve public safety. You put yourself in danger, you put the officers in danger, you put members of the general public who, again, if you injure or kill somebody out there engaging in conduct like this, they don't care what your motivations are or what's happened in your life. All they know is they've been severely injured. So that gives me a lot of concern. And while you may have been doing some good work at the Lions Den over the past 3 months, that amount of time is tiny in compared to the amount of time that you've spent doing things that have victimized other people. And at this point, on behalf of the court and behalf of our community, and I agree, Mr. Trush is right, the court has to look at what's best for our community. I'm not sure that 3 months of doing good things is enough of a record for me to bet the safety of our citizens here in Otsego County on that, or in Roscommon, where the Lions Den is. And when I look at the guidelines, a sentence within the middle of those guidelines is a reasonable sentence. I think it accounts for your past history and your conduct, both previously and in this particular case, the people that you put in danger. And then I think, because I think the court, an argument certainly could be made for a sentence at the high end of the guidelines, given your past record. But I think a sentence in the middle of the guidelines also recognizes the mitigating factors and the fact that you are trying to turn things around and do things differently going forward. So for all those reasons, again, I find that a sentence in the middle of the guidelines is reasonable and accounts for all the factors. So the court is going to, as to the fleeing and eluding charge, the court is going to sentence you to 24 months to 10 years in the Michigan Department of Corrections. You have credit for 26 days served on that charge as to count 2, resisting or obstructing. Again, also 24 months to 4 years in the Michigan Department of Corrections, again with 26 days credit. Those sentences to be served concurrent to each other. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $136 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Trush can provide Mr. McKenzie.
Jamie, over here, just so you know.
Date time set for a sentencing hearing in this case. Mr. Proctor had previously been sentenced to participation in the drug court program. He was unsuccessfully discharged from that program and is now before this court for sentencing on his underlying charge. Mr. Proctor, did you have a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, sir.
Mr. Brown, do you have any corrections either to the PSI itself or the update containing the information regarding the drug court participation?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, did the people have any additions, deletions, or corrections?
No additions, deletions, or corrections, Judge.
Any challenges to the scoring?
No, Your Honor, thank you.
Anything on behalf of the people for allocution today?
Yes, Judge. This is a situation where the defendant was given significant benefit drug court program. Since that point in time, he miserably failed that program. He had a driving license suspended on May 20th, 2025, a alcohol offense on May 16th, 2025, the July 24th, 2025, and failed to do drug screens on June 18th, September 4th. And there's a recommendation now that perhaps this confuses the people, because I could understand the scenario if the defendant hadn't been given that benefit and then failed it by not doing what he's supposed to. He was sentenced for his possession of meth offense on August 21st, 2025, with 9 felonies. But he was given, and his guidelines at that time were 5 to 28 up to 15 years. He chose again to throw all of that benefit away that he received, taking up the spot in the sobriety court program for somebody who actually perhaps wanted to dedicate themselves to sobriety. I don't think he should get a benefit of that, and it's somewhat confusing that if he successfully completed the program before how he was in it. But in any case, it's the people's position that this is the time for finally a penalty should be imposed. That, but quite frankly, people should have been imposed last time, and I think he should get an MDOC sentence, not simply getting 1 year in jail. Thank you, Your Honor.
Mr. Brown?
Your Honor, Mr. Proctor is here today. He obviously he injured his knee or his ankle, I believe. He is currently employed full-time. He does volunteer at various places as well. I believe he volunteers at a food pantry and helps at the animal shelter. He does have a lot going for him currently. He cares for his grandmother, who really can't care for herself here in Seago. There were some mess ups and those were very obvious, and it eventually came down to that kind of a recommendation for being taken out of the drug court. But he is still maintaining his sobriety. He did not go out and get high or get drunk or do something like that with potential of facing incarceration and not being in the drug court anymore. So he is still committed to that and continuing with those. I believe that he chairs some meetings on Tuesdays and Thursdays is what he told me, and he can go into that. And he's got a couple of people here to support him. So I would ask the court to take all those things into consideration when fashioning a sentence. He did successfully complete drug court the first time. So there is that potential, and I know he can do this.
Thank you, Mr. Proctor. Anything you wanted to say?
I would just like to go with what Larry said. I do chair the NA meetings on Tuesday and Thursdays. I have Alonzo back there. He's here to confirm. I chair that. The other lady there is my grandma. I take care of her during the day, while the other person we have living there takes care of her at nighttime. And then I am fully employed at Arby's. They're working with me because I am on crutches. Dislocated my left knee and sprained my right ankle. They let me sit in the chair and take orders. I know I messed up by relapsing, but I've gotten sober and stayed sober, and I continue to plan to stay sober. I don't have a want to use anymore. I don't have a want of even that urge. And I'm going to continue with the NA meetings, and once I can actually stand on my feet for longer than 2 hours at a time, I plan on going back to volunteering again.
All right, well, I read through the report. I'm familiar with the circumstances in this case. What brought you before the court in the first place and got you into the drug court program, and then of course your performance during the drug court program and the unsuccessful discharge from that. I've also read through the report, which contains a lot of information about your background, your prior history, and so forth. And I take all of that into consideration along with what the lawyers have had to say here today and what you've had to say. There's a couple of things that really strike me about your case. Number one, your past history, which is extremely negative. 9 prior felonies, 8 prior misdemeanors. You've been on probation 9 times prior. So I don't think, in my view, there's no point in continuing to put you on probation, especially given your unsuccessful discharge from the drug court program. That's some pretty intense supervision if you weren't able to comply with their requirements with as much supervision that you have there. I don't see you being successful on just regular probation. That and you know, we've done it 9 prior times, and at this point I don't think it's an appropriate use of the court's resources to continue to put you on probation when you're not able to comply with the conditions. So I don't think that's appropriate. You've had 6 prior jail sentences. So between probation, jail, even intense probation like the drug court program, there's been a lot of failures. And in my view, it's time to try something different because everything that we've done in the past has not been successful. I think it's encouraging that you've been able to remain sober since you were discharged from the drug court program. I think it's clear from your past history you've had periods where you've been able to remain sober. I'm just not convinced that that short term of sobriety has now changed everything and magically going forward, you're not going to use anymore. Your past history suggests that there's a continuing pattern of reoffending. And again, the things that have been tried in the past haven't worked. So I think it's time to try something different. Your guidelines call for a sentence of 5 to 28 months. And I think prison sentence is warranted in this case, given your past record and what's gone on in this particular case. The report indicates that you may be eligible for the boot camp program. I think that might be appropriate. That would allow you to be released from prison much earlier. I think that kind of intervention might be helpful to you, and it's definitely worth the try. So I'm stating it for the record here that I don't have any objection to your participation in the boot camp program through Department of Corrections. Again, because I think that might help where prior efforts have not. So it is the sentence of the court that you'll be committed to the Michigan Department of Corrections for a period of 24 months to 15 years. Again, I don't have any objection to your participation in the boot camp program. You have credit for 1 day served. Court is required to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Brown, can you provide Mr. Proctor with an acknowledgement of this? All right, please. Yes.
I believe the jail credit is 4 days. There was a few other days he was incarcerated. Looks like there was a bond set.
Okay, thank you for that correction. Credit of 4 days.
You have signed that acknowledgement. I've tendered that to the court.
Good luck to you going forward. Whatever you guys. Okay.
Judge, I'm sorry, was it 24 months to what?
15 years.
Okay, thank you.
What we just witnessed are two men standing at the crossroads of redemption and destruction. Jamie McKenzie, a man with a lifetime of bad choices, stood there owning up to his past. His words were honest, his emotions real. For 3 months, he turned his life around, working hard at the Lion's Den, helping the community, fixing cars, mentoring others. But the judge wasn't buying it. With over a decade of crimes behind him, the court wasn't ready to gamble public safety on a few months of good behavior. Jamie's plea for mercy was powerful, but justice came down hard. 24 months to 10 years behind bars. Then came Dustin Proctor, another man given a lifeline through drug court. He had every opportunity to walk free, but he blew it. Failed drug tests, new charges, and zero accountability. Even the prosecutor couldn't hide his frustration, saying Proctor took the spot of someone who actually wanted to change. The judge didn't hold back either, sentencing him straight to prison, cutting off his final chance at recovery. 2 stories, 1 courtroom errors, and 1 brutal truth. The system can forgive, but it never forgets. When you're handed a second chance, you either rise above your past, or let it bury you again. So what do you think? Did the judge make the right call? Or did these men deserve one more chance? Let me know in the comments. And if you love these real courtroom breakdowns, don't forget to like, share, and subscribe, because the next case, gets even crazier.